managing member and lead attorney for the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley, Montclair, New Jersey. Today's video is being recorded on February 20th, 2019 in New Jersey. If you're watching this at any time after this date, you need to check to make sure that the laws haven't changed. If you're watching this outside of New Jersey, or you're using the issues somewhere other than New Jersey, you have to make sure that it applies. In many states it won't. This is my weekly how-to series. For those that follow my videos, I do daily videos, I do weekly, and I do monthly videos. This is my weekly video. I try to give you sort of what I consider like a medium amount of information about an important tip or issue that comes up commonly in divorce and family law in New Jersey. This week's video is how to choose the best mediation process for your New Jersey divorce case. You will learn, if you are in a divorce in New Jersey, the large portion of the court's process itself is mediation processes or hearings. The court will send you through a number of different hearings to help you resolve your case. This video does not discuss those at all. I'm not sure if I did a video on the other ones in the past. I probably have. I'm considering doing another one maybe next week where I go through the settlement conferences that the court will put you through. This is the ones that you can choose outside of the court's process, and I'll give you some information both about the process itself and the sort of pros and cons of each one so you can know which will suit your case best. So essentially there's four main types of mediation processes. First is mediation. The second is collaborative law. The third is arbitration, and the fourth is binding arbitration. Mediation is where you retain a third party, like another attorney, a retired family court judge, an accountant, depending on what your issues are. That third person is in charge of helping the two of you negotiate a settlement in your divorce case. It could be in the family law case also, too. The purpose is that person helps you to bridge the gap on the issues where you need some movement and you can't agree on your own. It is confidential. Actually, all of these are confidential, so I won't repeat that as I go through that, but it's confidential, so whatever you discuss in the mediation process doesn't go into the judge's chambers or into your hearing whatsoever. The second is collaborative law. That's been a real popular buzzword in the last couple of years. I haven't seen many cases actually engage in it. That is where all the parties agree in advance that they're going to work towards a common goal, whether it's to protect the children's best interest or to equitably divide property quickly. You're agreeing that you have a shared common interest. It's not an adversarial kind of case or process. The purpose of collaborative law is the people that you retain, like your expert witnesses, your counselors, your lawyers, are all working together to help you reach an agreement. Sounds similar to mediation, but it's different because in mediation, you're at different ends of a conversation or an issue, and the mediator is trying to bridge that gap. Collaborative law is the intention that you're going in with is shared. Now, in this process, you're agreeing that everybody that gets involved in it is also bound by the same confidentiality that you are in mediation. But the difference between those two, the mediation and collaborative law, is if collaborative law fails and it does not reach an agreement, you do not reach an agreement in the process, all of the people that you've hired and paid for attorneys and experts are barred from participating in the contested litigation. Next is arbitration. Arbitration is similar to mediation. You hire a third person to hear the different issues and to make a decision. Mediation and arbitration are different in that mediation, the mediator helps you reach an agreement if at all possible. The arbitrator makes a decision. So whether or not you agree at the end of arbitration, you'll come to an actual decision from the arbitrator. The process of arbitration usually follows the similar process to having a trial, but it's usually it's usually less formal and less structured, even though they follow the same rules of evidence and the same proofs that are needed. It's usually less formal and it'll be easier to engage in. It's also much faster than both mediation and trial and even collaborative law, because mediation can happen over a series of sessions. Collaborative law can occur over a series of several months, depending on what you're engaged in. And arbitration will normally have set days, like a trial date, where you give testimony and a decision is rendered. And then last is binding arbitration, which is obviously the same as arbitration. The main difference, obviously, in the description is arbitration is where you're getting a decision made instead of trying to make an agreement in mediation. The arbitrator will give you a decision, but either party can elect not to be bound by it and return to the trial court for a trial, as opposed to binding arbitration, where you're agreeing in advance that the arbitrator's decision will be binding, absent very limited reasons under New Jersey law that you can appeal it. So let me just now go into each one, my personal thoughts about it and how they work, so you can know whether or not it fits right for your case. Mediation only works, I usually say mediation only works for people who don't need it. And that's because mediation is only effective if you have two very reasonable people that want to come to their own agreement. Now, if you have two reasonable people wanting to reach an agreement and minimize costs and expedite litigation, you don't really need to hire a third person if both of those have an attorney or understand their issues, because now you have probably three attorneys getting involved in the mix. More often than not, I see cases where one party wants mediation because they can sort of usurp some control into the proceeding, because it's confidential, it's in a closed room. Sometimes there's not going to be equal bargaining power, there's not equal control over finances, difference in parenting schedules, whatever it may be, but there's more often than not what I see, they're not equal and they're not amicable. The only time mediation is going to be effective, not the only time, it's more effective and faster if the parties truly are reasonable and get along well enough. If they both have lawyers, I don't think mediation or a third mediator is necessary, but it's certainly a good process if you're looking to expedite the hearing and your case instead of going through the court-sponsored processes of mediation, because it's faster, but it costs more. Most of what the court will put you through is free, and you're going to pay a mediator separately. So mediation is good if you have two reasonable people that are looking to expedite the case and resolve it. Collaborative law, I, to this date, have never seen the actual case go to collaborative law. It's a very complex process, even though it's intended to facilitate resolution. It's complex because you're hiring all these people and you're agreeing that if you spend all this time and money, that none of them can participate in your case afterwards. So you're investing a lot with the hopes that it works. Similar to mediation, if everybody was that reasonable and cooperative in the first place, I don't think you would need all of this structure around having a collaborative agreement, hiring all these people that agreed not to get involved later with the hopes of resolving it. What I normally tell people to do, especially in collaborative law, this will sometimes work with mediation, but if you're considering engaging in collaborative law, take one of your positions and inflate it a bit, not unreasonably, but change your position a little bit and ask the other side if they're going to be considering this issue. Like, for instance, I'm trying to think, like, never say something like you don't want to pay child support or you're looking to move out. But, like, let's say you have a custody arrangement and you want equal parenting time. Ask if the party's going to consider a nesting arrangement, which is where the children stay in one house and you switch residences, the parents move in and out. Something like that, where you're taking a position, but you're pushing it a little further. Because more often than not, the other side's going to say, no, I'm not going to consider that. It's not something that's on the table. It's not something I'm willing to consider. And that tells you right off the bat that they're not good for collaborative law, because the purpose of collaborative law is to be open-minded to everything and work together. If you go into a collaborative process saying there's something that I'm not willing to consider, anything, one thing that you're not willing to consider, then it's not a good process for your case. It's only good if everybody's willing to work together. And again, my opinion is if everybody's willing to work together, it's not a good process. Arbitration is one of my more preferred. It's probably my most preferred, except for binding arbitration is my most preferred. I'll get that in a second. Arbitration, I think, is the best when you have cases that don't work well for mediation or collaborative law, which is the average case, because people are not usually that accommodating in divorces, or at least when they come into my office. So arbitration is good because you're getting a decision, you're following a process, and it's expedited. The biggest problem you'll have in New Jersey divorce court and even family court with the trial is judges hate giving you trials. They will do everything they can not to. So even if you have a trial date, more often than not, you go out that Monday morning at 9 o'clock or 8:30, and they tell you to sit in the hallway because they have 10 other things. And they say, well, try to settle your case. And then, or they'll take an hour or two of testimony and then tell you to come back in a month, and you're prepping it all again. So hoping to get a trial in New Jersey is very, very difficult and costly. Arbitration is not, because you've taken it out of the whole process. You've hired an arbitrator who's usually an experienced attorney or retired family court judge, so people who know the law and know how decisions should be made. They're taking the same information, but they're doing it on a schedule that you set, on days that are promised, and for as long as you're willing to be there. So you save a lot of time, a lot of money, and a lot of stress going to arbitration. The only downfall to arbitration is if it's not binding, it's exactly the case, it's not binding. If you come out with a bad decision, you're right back into the process, and it's been a waste of time other than the preparation and getting everything ready. But it's still, of the first three, my favorite because it's quick and it's less costly and it's efficient. Now, binding arbitration is my favorite, especially when you have a high conflict case, or either when you have a high conflict case, disputed significant issues like custody, or issues that you don't want to bring into court, like allegations of fraud or tax evasion. For reasons I won't go into in this video, but if you have these issues, you'll learn why you shouldn't bringing them into a trial court. So binding arbitration is great for the reasons that, same thing as the regular arbitration. It's expedited, it's less formal, it's less costly because it'll be done on the days that you're promised and when you're there, and you get a similar decision to what you would in family court. And sometimes even a little more creative because they're not bound as much by the formalities of the rules. The only drawback to binding arbitration is just that, exactly that, it's binding. And there's very few reasons under New Jersey statutes where you can appeal an adverse arbitration decision. And what's important to note, if you are considering going into binding arbitration, as far as I know, as of this date, there are two separate statutes that govern arbitration, and each statute has slightly different reasons for which you can appeal. One is more broader than the other. So if you're going into binding arbitration, make sure you're familiar with which one you're choosing, which statute applies, so you know your appeal rights. So in a nutshell, those are the pros and cons. Again, my favorite is binding arbitration. My least favorite is collaborative law. Mediation and arbitration fall somewhere in the middle. Best way to figure it out is, based on some of the issues I'm talking about, how complex your issues are, how contested your case is. The more contested, the more complex, the more you need arbitration and binding arbitration. The less complex, less contested is collaborative law and mediation. So I hope this information helps you if you're going into a divorce or a family trial. I hope this information helps you decide which one is going to be best for your case. If the information was helpful, please give this video a like and share it so other people get to see it. You can also subscribe and ask for notifications so that you'll get notified when I do go online. I'm intending to go on tomorrow again at 4 o'clock for my daily tip. And if you want to see anything in particular for that information or any upcoming videos, just message me either through the channel that you're watching or my email, which is brad@micklinlawgroup.com, which is MICKLIN lawgroup.com. Thank you.